The final story we're going to talk about today is a court ruling on the latest court ruling on the ATF's pistol brace ban, where for the first time we now have a district judge issuing an injunction not on administrative procedure grounds, but actually on a finding that they may be covered by the Second Amendment. If you want to talk about that ruling that you wrote up.
Yeah, big change here, right? Because we've talked about these cases, the ATF rules, the President Biden's unilateral action on gun policy, where he's trying to ban these different things. And those have mostly been stopped, including, and President Trump before him with the bump stock ban. And all those had been stopped on APA grounds, Administrative Procedure Act grounds, like essentially that the ATF doesn't have the authority to do these things, instead of the fact that the idea that these accessories and firearms are covered by the Second Amendment. That's a totally different argument that hasn't really come up in these cases, at least not in the rulings against the ATF. So that's a pretty big sea change in this case. And now you have Judge O'Connor, Reed O'Connor. He's been involved in this case from the beginning against the pistol brace ban in the Fifth Circuit. And he actually initially denied, if you remember all the way back, the first ruling from him was denying the injunctions against this rule. And then the Fifth Circuit panel of the appeals panel granted them. And so now he has to go back and relitigate this stuff under their reasoning. And so, but he came to the conclusion that yes, pistol braces or braced pistols, firearms that have pistol braces on them, are in fact protected by the Second Amendment, and that they are, more importantly, in common use for lawful purposes, right? That was sort of the bottom line of what he found. And therefore they can't be banned or restricted in the way that the ATF wants to do that. And that has a lot of implications, I think.
Yeah, absolutely. Especially because he drew on a lot of the findings during the when the regulatory rulemaking was going on, sort of the findings of the ATF's estimates of how many braces that were out there. He used the lower end estimates, it's the 5 to 7 million or whatever, maybe 4 to 7 million, 3 to 7. Yeah. And obviously we've seen the Congressional Research Service estimate could put it up as high as 40 million potentially. But either way, him narrowing down on that 5 to 7 or 3 to 7 rather million braces and saying that represents, a commonality for, use among law abiding people, you wrote about in a members piece, has huge implications, not just for pistol braces, but for all sorts of Second Amendment hardware ban cases, right?
Absolutely. And by the way, he also cites our reporting when he was considering whether to issue this injunction, because according to the ATF, from what they told us, they'd only registered, I think 250,000 of these, or maybe 750,000. I can't remember. It was about 8% registration rate, going off the low end estimate of how many are out there. And so part of his point was that there are a lot of people still, specifically FPC members, that, they got into the whole thing of wanting to avoid a nationwide injunction, but also grant the widest possible relief to the plaintiffs in the case. And the plaintiffs in this case include the Firearms Policy Coalition and all of its members. And so he's sort of implying that a lot of FPC members probably have these guns and haven't turned them in and are now could be subject to prosecution without an injunction. So that's where he used our reporting in this case. The Fifth Circuit had cited our reporting previously as well. But the more important aspect is this idea that 3 million pistol braced guns, or braced pistols, or whatever you want to call them, qualifies as being in common use. That's important because the common use standard came up almost 15 years ago at this point in Heller, but it hasn't ever really been articulated as to what constitutes common use, right? You've had a couple things where judges have opined on this. You had Justice Alito in Saitano briefly talked about common use in regards to stun guns, where you put the estimated number as low as 200,000 of those. And he said that makes them in common use because they're available all over the country and there's hundreds of thousands of them, and, owned by people who are law abiding. And so you had that, but that's one justice in a concurrence. And so anytime you get a new case where a judge is opined on this topic, what exactly is common use, I think that's extremely important and very relevant. Now, look, he puts it in the millions. Millions was sort of the bottom line for him. Yeah, he cites the 3 to 7 million, but he just says millions owned by people that the ATF admits themselves were law-abiding, that bought them legally at the time. And so that, to him, that puts them in common use, which makes them protected under the Second Amendment, which means you'd have to have some sort of, with Bruin, you'd have to have some sort of historical tradition of barring commonly used firearms like this, which doesn't exist. And so therefore, you can't ban them. You can't heavily restrict them the way the ATF wants to do. And I think this creates huge implications for, every hardware ban basically, right?
Yeah, I was going to say, yeah.
I went through all of them in that members piece, and, there's sort of variations in how many there are and how accurate or how reliable the estimates of those devices are. You start off with magazines, which you've got almost certainly the most magazines that are affected by these high capacity bans, even though the definition of what high capacity means changes from state to state, sometimes from gun to gun within the state, right?
Yeah.
I think Washington or Oregon, they set a different standard for handguns and rifles for some reason. Yeah. And then, but yeah, it could be 10 rounds, it could be 15 rounds, it could be 12 rounds, 17 rounds, it changes. And there's really no way to know how many are out there because nobody keeps records of magazine sales. They're not usually serialized devices, so you couldn't figure it out even if you wanted to. And the best estimates that I've seen are like, I think plaintiffs in magazine ban cases have used 115 million, right, as one estimate. So they're probably the most numerous of the things that get targeted for bans, right? And that, certainly even if you're an order of magnitude off, they're going to be in the millions. Then you go to ARs, right? So-called assault weapons. Again, you have the same definitional issues where an assault weapon in California is not the same thing as an assault weapon in Maryland. And you have a little bit more reliable estimates because they're based on an industry analysis by the National Shooting Sports Foundation of ATF reports on manufacturing records, but the manufacturing records don't really get into like the exact models that are made. They're more broad than that, but they are at least sort of required reports manufacturers have to hand in to the ATF of how many of a particular kind of gun they made or class of gun. And then the NSSF goes from that to try and figure out how many are out there. They put that number at 24.4 million. Really, ARs and AKs is what they're looking at. Assault weapons laws usually apply to a much broader swath of weapons than just ARs and AKs too. But regardless, even if that's way off, you're still probably well into the millions there. And then you get to silencers or sound suppressors, right? And that's where you get the most reliable estimate because every suppressor, as we kind of went over earlier, has to be registered with the ATF under the National Firearms Act. And so you have probably a pretty exact count of how many of those exist. And last report that the ATF put out, I think it was 2.6 million registered, and that was in May of 2021. So they're probably more than that now. They might have reached that 3 million mark. That is the low end estimate of braced pistols from the ATF. So, that also calls into question perhaps the NFA itself because of the fact that it's trying to restrict these commonly owned devices, silencers. Now, there is, of course, with magazines and silencers, there's going to be this side debate about whether they're arms or not.
Right.
And that's still a live legal debate. And that's how a lot of these the magazine bans that we've seen upheld, as you wrote about in a members piece not long ago, I think last week, actually.
Yep.
that's often how they're upheld, by claiming that high capacity magazines aren't arms that are protected by the Second Amendment, even if there are a lot of them out there.
Right.
And then they also get into a different standard of common use, right? The Judge O'Connor uses a standard of commonly owned, essentially, and people own them for self-defense, right? That's often the intention of people who buy these devices and firearms. But the standards we've seen from judges who have upheld magazine bans, they say common use for self-defense. And what they mean by for self-defense is literally you have to fire more than 10 rounds in a self-defense encounter for it to count as being used for self-defense. So that's where things start to diverge on the court level. Although I would imagine the Supreme Court is probably siding with the O'Connor view of this over the other view. So we'll see, though. We'll see how it plays out.
Right. Yeah. It depends. Obviously this is just a district court judge, so this isn't precedential or anything like that. But like you said, it's a very interesting argument. It's the first time we've seen this now in these ATF rule cases. And if it's an argument that takes off with other judges and potentially higher level circuit court judges, could see that becoming precedent and very influential going forward. So.
Yeah, and I mean, that's what, honestly, gun rights advocates have been waiting for 15 years since Heller was handed down, and what gun control advocates have been fearing for 15 years. And it hasn't happened yet, right? So even after Bruin, we haven't, the Supreme Court certainly hasn't gotten involved yet. We haven't seen a lot of these hardware ban cases make it into final decisions at the appeals court level, the circuit court level yet. So there's still going to be some time, I'd imagine. And, maybe it'll take another 15 years. It's not a guarantee, but you are starting to see more of this outcome, this logic running through the courts now. And I do think that it will probably continue in that direction, and it won't be very long at this point before you do start seeing those hardware bans get knocked out in higher court rulings, and potentially at the Supreme Court sooner than later.